I'm Dru Stevenson, and this is a video for my Law and Economics seminar for our unit about constitutional law and economics. And in this video, I already did one that was an earlier one that was a sort of overview video. This one is about supermajority requirements for changing the Constitution. How difficult it is to pass a constitutional amendment, for example, or to repeal an amendment, and sort of the economic traits or characteristics and consequences of that. Now, for my class, keep in mind that I outlined in another video basically 8 different interdisciplinary areas of study between economics and constitutional law, right? The idea of studying, having a constitution at all or itself, and then different types of or features of constitutions. And in this video, we're specifically focused on sort of the permanence of the Constitution. And the constitutions by their nature are different than statutes. They're harder a statute is fairly routine to enact and repeal or amend. Regulations are even a little bit easier to promulgate and rescind. And constitutional provisions are basically the part of our system of legal rules that are quasi-permanent or semi-permanent. So let's talk about some of the features and implications of that from an economic standpoint. So first of all, you could think about this in terms of transaction costs. So amending a constitution has high transaction costs, especially the federal one. Now, some state constitutions, like in Texas, are much easier to amend, and we do it a lot more frequently than the federal constitution. But in general, when we talk about national constitutions, they're hard to change, and they are intentionally hard to change. And this has some implications, right? So first of all, they're going to be changed less frequently. They can give more stability to the legal system and become kind of more permanent features or underlying characteristics of the legal system, as opposed to a statute, which is more transitory. Also, the fact that they have high transaction costs makes them a little bit more like a contract, if we're comparing them to other things in economic terms, than a statute. In other words, a contract can be changed only by mutual consent of the parties. And so if you're analyzing it in terms of how many people have to agree to this, a constitution is essentially, if you think of it as a type of social contract, it's a contract with a lot of parties between the entire sort of citizenry, or at least all of the state legislatures. And so that's very difficult to change, just like contracts. In theory, you may think that because a contract is a private legal instrument, that it's easier to change than a statute. But the fact is, you have to have both parties willing to make the change, and a statute can usually be changed unilaterally if by whichever party has control of the legislature. And so obviously that's something that scholars could write about, or that you could do a whole paper about, is analyzing the transaction costs involved with amending the Constitution, and comparing and contrasting it to other written legal documents like contracts and statutes. So let's keep going, though, with this idea of the implications of having high transaction costs for change or semi-permanent legal rules. So let's talk about factions or special interest groups that are seeking constitutional protection. It's very difficult and costly to obtain, but it's also so hard to remove later that it might be worth it, right? It might has great long-term value, offsetting the cost of obtaining it by the interest group. And so if you think about something like the women fighting for the right to vote in the early part of the 20th century, and the suffrage movement, this was very hard and took years and years of concerted effort around the country to pass an amendment so that women could vote in the United States. But it was worth the struggle, because once you get it, you're probably going to hold on to it. Now, there have been a few amendments that we've repealed, right, like prohibition, but most amendments, once we get them passed, are here to stay. And so if you could think about other groups that feel like they are face a lot of discrimination or mistreatment in our society, who might be kind of advocating for a constitutional amendment to give them protection, or at least put them on the same standing footing as other groups that don't share their traits. So this could be especially valuable for groups who expect to have less political power in the future. Now, that takes, I think, quite a bit of prognostication or foresight to imagine that. And I'm not sure that women in the early 20th century imagined that felt like their power was declining. But we do live in a society today where there are groups who feel like they've been losing ground in terms of their political power and market power and so forth. And so if you're part of a group that you feel like has been kind of losing power or is going to lose power in the future, or you're part of let's say a religious minority group that faces sort of sporadic persecution historically, and so you never know when it's going to start again. This fighting for a constitutional amendment for protection can be especially valuable if you expect that the day will come when you actually need that, and you can't just rely on your political power of having a majority of support in the legislature. Let's talk about the courts. And there's a sense in which, right, that activist courts that kind of come up with sort of novel interpretations of the Constitution or break with tradition are in some sense amending the Constitution. And so one of the areas of economics and constitutional law has been sort of to argue that let's say the Warren Court era or the current Roberts Court has essentially been engaging in sort of shadow amendments to the Constitution because they've so drastically changed the interpretation of it. So we instead of going through they bypass the supermajority requirements for creating an actual textual amendment, and have just done that by interpretation in the courts. And the question is whether this creates agency costs. That's an economic concept where you have a principal and an agent. Essentially, think of it as an employee or somebody, a lawyer, someone you've hired to act on your behest, who doesn't always do what you want. And so the question is, are activist courts, whether they're liberal courts or conservative activists, are they straying from the framers' intent? Now, note that it's easier to do this with more general provisions of the Constitution or clauses than specific ones, right? So the more open-ended something in the Constitution is, like the take care clause or something like that, the more latitude you have to sort of strain meaning out of that, to interpret it broadly or narrowly and so on. Something that's very specific, like the minimum age for the president, is a little bit harder is not as elastic, right? And doesn't really invite reinterpretation as a way of sort of changing the law, the Constitution unofficially. When we talk about straying from the framers' intent, though, we also have to answer the question of how much did the framers intend to restrain Congress in future generations. I can tell you from reading the debates in the first Congress that people who were debating about the Bill of Rights, that members of the first Congress disagreed among themselves about how much freedom courts in future generations should have to reinterpret the Constitution or add new rights. Some of them were very concerned that the language that they were putting into the Bill of Rights would be construed too broadly someday by future courts. And so the question is whether that shows that they were worried, they wanted the courts to be faithful to their intent, or did they recognize that they had created a document that inherently allowed for that, and therefore they needed to choose their words carefully if they didn't want them to be reinterpreted later on. Okay, so the Constitution, you could think of it as having specific clauses and general clauses. And the specific clauses are more likely to be mere conventions, like the rule that we have 2 senators, or minimum age rules for voting, or the president, or something like that. And so we could have had 3 senators from each state, right? It doesn't, there are implications and consequences of having 2 versus 3, but you have to pick some sort of number, and so that it's sort of set. And that was the idea, is that there are certain legal rules, or rules in our legal system, where we've had to draw the line somewhat arbitrarily. Maybe there was a good reason for where we drew the line, but the fact is we just had to draw a line, like set a date. If you think about it, in law school or college, the deadline for registering for classes, right? At some point you have to have a deadline if you want to sort of finalize the schedule and have professors know which classes they're going to teach and who's in the class, and so forth. So the number in the Constitution itself matters less than the fact that we are going to have consistency and uniformity and predictability. And it would be inefficient if interest groups were constantly trying to change these rules, right? So if you imagine a special interest group that really wants to reshape society in their image, some sort of a radical group, let's say, and they're less likely to focus on getting more senators than they are in trying to convince courts to reinterpret one of the provisions of the Bill of Rights more broadly or narrowly to sort of fit with their agenda. Okay, and that concludes my short video about the this aspect of interdisciplinary studies between economics and constitutional law.